India, but due to the provision of the Berne Convention, the music copyright was protected since it was fixed on a CD or cassette, though registration was not made for that. And you know, unregistered trademarks and GIs are also protected in common law countries. So in Bangladesh, we do follow the common law. In India, but for GI to get protected, it requires to be registered beneficiary. And you get GI registered for that, and thereafter you can apply for GI registration in Bangladesh. And without getting it registered in India, it cannot be registered in Bangladesh. You know, there are other treaties like the Patent Cooperation Treaty, Madrid Agreement with Madrid Protocol for Trademarks, Hague Agreement for Designs, and Lisbon Agreement with the Lisbon Act for Geographical Indications. And under these treaties, if any of the intellectual property, relevant intellectual property is registered in a territory, then it will be protected in all member countries. But unfortunately, Bangladesh is not a party to either of them. However, there are some discussions going on to accede to the PCT Madrid Agreement with the Madrid Protocol for trademarks, and maybe in course of time, Bangladesh will be a party to such sort of treaties to get simultaneous protection for intellectual property rights called patent or trademark. Now, I'll talk about institutional issues, and maybe some of the issues are very clear. Institutions dealing with intellectual property rights. And there are certain burden vested on the Department of Patents, Designs, and Trademarks. That is, in short, it is called DPDT, Department of Patents, Designs, and Trademarks. It is a department run under the Ministry of Industries, and it deals with patents, designs, trademarks, and also GI. And the DPDT consists of the registrar, deputy registrar, assistant registrar, and examiners. And the post of registrar and deputy registrar recruited through the Bangladeshers. These officers may come from different subject areas. Maybe some of them have studied in, say, he will be posted at the Department of Patents, Designs, and Trademark as the registrar or as the deputy registrar. That means these officers may not know intellectual property at all prior to on being posted at the department. Such officers try to learn intellectual property, especially industrial property, or sometimes they receive foreign trainings. But within a few years, or sometimes after a few months, they are transferred to other ministry positions. That means they started learning intellectual property, but within few months or years, they are posted to other ministries. That means initially they did not have any intellectual property, and they tried to get some, but they are posted to other registration and non-registration decisions and orders. That means for certain intellectual property registration, there may be an order for registration, or there may be a certain order for refusal. And the registrar will make such sort of decisions. And against the decision or order, the Patents and Designs Act has mentioned that the Secretary of the Ministry of Industries will dispose of the departmental appeal from a discipline called, say, gender studies. And he will sit in the ministry as the secretary, and he will be the appellate authority in disposing of departmental appeals in cases of patents, designs, and GIs. Very interesting. And against the trademarks, registration and non-registration decisions or orders, an appeal lies to the High Court Division of the Supreme Court of Bangladesh. Similarly, the protection of copyright office, a department run under the Ministry of Cultural Affairs, as I told you earlier. It consists of the registrar, deputy registrar, resident registrar, administration cadre, and they may not know intellectual property prior to their posting in the department. While they will be posted in the department, they will try to learn intellectual property, especially copyright, or they will go abroad to receive foreign trainings. But still, within few months and years sometimes, they may be transferred to other ministry positions. And at the time of working at a copyright office, the registrar or deputy registrar make registration and non-registration decisions. In the Copyright Office, there is another authority called Copyright Board, and it consists of a chairman and not less than 2 or more than 6 other members appointed by the government. But the registrar shall be the secretary of the board. And this chairman may be a person who is or has been a judicial officer, not below the rank of a district judge in the selection grade, or an officer not below the rank of an additional secretary to the government, or who is an advocate qualified to be judge of the Supreme Court. That means the BCS, Bangladesh Civil Service Administration Cadre officers may be qualified to act as the Copyright Board chairman, and he can dispose of appeals against the decision of the copyright registrar. In addition, he requires to perform other functions as well. And it is interesting to be noted that the Copyright Act is silent about other members of the Copyright Board. That means who will be the members, other members of the Copyright Board. And for all purposes, the registrar or the Copyright Board will be given the power of a civil court. And in the Copyright Act, it has been mentioned that they will act as the civil court for the purposes of section 482 and 480 and 482 of the Code of Criminal Procedure, 1898, or all proceedings placed before the board are taken to be judicial proceedings within the meaning of section 183 and 228 of the Penal Code, 1860. And as I told you earlier, that the board can dispose of appeals. It can also dispose of disputes arising out of copyright assignment. It can also fix the resale share rights in original copies. It can disclose the identity of an author in the case of pseudonymous work of joint ownership. The Copyright Board can grant compulsory licenses in works withheld from public and in unpublished Bangladeshi works. Further, the Copyright Board can grant license to protect and publish translation of works which are commonly used in the country, but the creator is not interested to produce and publish translation. Further, the Copyright Board can grant license to produce and publish works for certain purposes if such works are not made available to the general public, or in connection with systematic instructional activities at a price reasonably related to the normal charge in Bangladesh for comparable works by the owner of the right of reproduction or by any person authorized by him in this behalf. So from the above, it can be seen that there is no uniform departmental appeal forum here in Bangladesh. But you can compare the situation, we can compare the situation with that of India. And I think in every department, there is an appellate authority and there may be judicial member in the appellate authority. But here in Bangladesh, excepting the copyright board, there is no mention of appointing member in the appellate authority. Further, for civil remedies, in all, the Court of District Judge does have the original jurisdiction. That means if any infringement for any intellectual property takes place, then the aggrieved person can go to the Court of District Judge and can claim remedies. But it is to be noted that here in Bangladesh, the subject intellectual property law is not compulsory in the university or in law colleges. That means without having studied intellectual property law, a very specialized area of law, someone can become a judge and he will be burdened with the work of disposing infringement cases. Further, in the High Court Division of the Supreme Court of Bangladesh, and I think I must mention that we do have the Supreme Court consisting of two divisions. One is called the Appellate Division and another is called the High Court Division. The High Court, lowest court in the Supreme Court setting, and in the High Court Division, there is a special bench for company matters, and it usually hears intellectual property cases as well. But it is unknown whether this very bench does have expertise in intellectual property law. For criminal offences relating to copyright, the Court of Sessions does have the jurisdiction. For trademarks and GI, the Court of First Class Magistrate, or in metropolitan areas, the metropolitan magistrate does have the jurisdiction to try offences relating to trademarks and GIs. For patents and designs, there may be some punishable criminal offense due to the wrongful use of the words Department of Patents, Designs and Trademarks, but no forum for such trial is mentioned in the Act. And so far, there is no necessity felt, and the forum is still unclear since 1911 when the Act was adopted. And I think in India you do have the similar law until 1970 when you did have your Patents Act. And before that, you'd have the same law like us. So it appears that for trying criminal offences relating to intellectual properties in the country, there is no uniform forum as well. Further, under the Penal Code 1860, criminal offences relating to intellectual properties are also triable. I think same thing happens to you as well. You'd have the Penal Code like us, inherited from the British colonial system. To get quick remedies, lawyers often advise their clients to initiate criminal proceedings under this law. That means to get remedies under Patents and Designs Act or the Trademarks Act or the GI Act, the aggrieved person may have to wait a longer period of time to get remedies. But if he initiates proceedings under the Penal Code, he may get the quick relief. In addition, the Mobile Courts Act 2009 is also empowered to try offences relating to intellectual properties, where the sentence does not extend to more than 2 years. And under the Mobile Code Acts, there will be Mobile Code headed by some executive magistrate. Again, the executive magistrate is not from law, and they may be given some training on penal laws, but they are given the authority to dispose of intellectual property related offenses. And further, here in the country, we do have intellectual property attorneys, but who are they? Intellectual property attorneys are those people who are enrolled by the Bangladesh Bar Council to be an advocate. They may not have studied intellectual property law in their University of Law College degree, since it is not studied as a compulsory subject in most of the law schools, as I told you earlier. To get enlisted to work as attorneys in the Department of Patent, Design and Trademarks, or in the Copyright Office, they don't require to have any training or course on intellectual property. And without having studied intellectual property, someone can become a lawyer under the Bangladesh Bar Council, and they can act as an intellectual property attorney here in Bangladesh. Very interesting to know that. Now, I will talk about patent. As I mentioned in my topic, that a special focus will be on patents. And as I told you earlier, that we do have the Colonial Patents and Designs Act 1911, and it is not yet made TRIPS compliant. And I also mentioned earlier that Bangladesh will move to developing country in 2026. And before the graduation, Bangladesh is under obligation to comply with the TRIPS fully. To that end in view, the government is considering to enact two laws, namely the Patents Act and the Designs Act, of which the Patents and Designs Act is currently under the process of vetting by the Law Ministry. And it has given the approval by the Cabinet, and maybe soon we'll have the Patents Act. And so far I have heard that the Law Ministry is also preparing the draft for the Designs Act, and before 2026 we'll have the Designs Act in place. And as I told you, that till 1970 you did have the Patents and Designs Act, and in the Patents and Designs Act, patents can be given for products and processes. And the term invention here includes any new product or any new process or any improvement thereto. That means if there is an invention for a product or process, that will be patented if that product or process fulfills the criteria, very criteria of novelty, inventiveness, and industrial application. But the term invention also includes the very term improvement. And the term improvement is not defined here as well. Now, the question arises whether any silly improvement to the existing or patent expired product or process will qualify for a patentable invention through the patent evergreening. I think you do have the similar provision in your act, called Section 3D. And I think there you'll find that very word substantial improvement or something like that. That means there may be a patent expired and the patent owner can include certain ingredients therein, and if that inclusion is substantial in nature for this, the product may be an improved product and it may qualify for a product patent. But here in Bangladesh, we don't have any definition of improvement. Even this issue of defining improvement is not yet raised before the Supreme Court, where we could have the interpretation, we could have the case law, how long the improvement may be to qualify for an invention to be patented as well. Further, the Patents and Designs Act is silent about what cannot be patented. And if you go through the TRIPS agreement, especially Article 27, you'll find the list for which the country can exclude inventions from patentability. And in a country like us, we don't have a lot of inventions, but maybe in course of time, if the inventions are placed in the public domain, if the invention, a patent for the invention expires, then the local company can generate of the product or process. So as soon as the patent expires, it will be useful for us. So from our point of view, there should be certain exception clauses so that the patent can be used early. However, there is a provision for patent revocation in the Patents and Designs Act, and according to that provision, if the patent of the mode in which it is exercised is declared by the government to be mischievous to the state or generally prejudicial to the public, that means the Patent Act is silent what cannot be patented. Say, I'm giving you an example. Say the human cloning. Can it be patented? Say in the European Union, in Japan, in some other parts of the world, human cloning is not a patentable invention. Now, what's about in Bangladesh? Can human cloning be patented? Since we don't have any exception list, it is patentable. However, later on, if the government thinks that the human cloning is mischievous to the state or generally prejudicial to the public, then that human cloning on the human cloning can be revoked. So initially patent may be given, but later on, by interpreting Section 25 of the Patents and Designs Act, the patent can be revoked as well. Now, the very question is, can the pharmaceutical be patented in Bangladesh? I think I can compare our law and your law before 1970 and after 1970. As I mentioned that we do have the same law for you until 1970, and under the pharmaceutical can be patented. But in India, as it did in 1970, you offer process patent to pharmaceuticals, and you did not offer product patent to pharmaceuticals. That means, say, a Swiss company can have a medicine made, using certain process, and if that medicine company comes to India, you could have patented that specific process, but other companies are free to make that medicine by using other processes. Since product patent was not in force, other companies could have used other processes to produce that medicine. But here in Bangladesh, we did not make an amendment to that law since 1911, and under that law, a medicine as a product or a product made of processes will be patented. It is to be noted that Bangladesh and LDC possesses a vibrant $2 billion or around 1% gross domestic product from its pharmaceutical industry, which produces off-patent or one-patent generic medicines and supplies them at home to fulfill almost 90% of the entire domestic needs. And it also exports to more than 100 countries, including the US. Further to be noted that a fifth of the total medicines produced are on patent, but patented elsewhere that is not patented in Bangladesh. That means the local companies produce generics of the medicines, and the medicines may be off patent, maybe one patent. But one patent means it is patented somewhere else, but not in Bangladesh. Why? Because we stopped patenting pharmaceuticals sometimes, later on. I'll talk about that in a moment. So in Bangladesh, patent will be given for a pharmaceutical product or a process. And until 2008, Bangladesh offered patent protection to pharmaceuticals as a product or a process. But in 2008, it stopped offering patent protection to pharmaceuticals. Why is that? I'll talk about that in a moment. You know, at the time of compliance, TRIPS compliance by developing countries and LDCs, there were certain relaxations of the TRIPS, especially under Article 70.8 and 9, and under several TRIPS Council and WTO General Council decisions. LDCs having no existing patent regime and developing countries not offering product patent to pharmaceuticals were required to establish the mailbox with effect from 1st January 1995 for storing applications of pharmaceutical and agricultural products. That means, say, as I mentioned, that India since 1970 to 1995 did not offer a patent protection to pharmaceuticals as a product. And there are certain LDCs having no existing patent regime, and for them, the TRIPS obliges them to not to offer product patent not to offer patent protection to pharmaceuticals, but to put the applications in the storeroom, and it mentions that whenever the transition period will be over, they will process the application and they will offer patent giving retrospective effect. So for a developing country like India or other countries, they complied with the TRIPS by 2005, and for LDCs, the transition period is getting extended. So as I told you earlier, that for the LDC, the transition period is until 2034 or until that country moves to developing country, whichever date comes around here. And as I mentioned earlier, that since Bangladesh is an LDC, it will have the transition period, but this transition will expire for this country in 2026, since it will move to the developing country status at the time. So Bangladesh did have an existing patent regime. So TRIPS Article 70.8 and 9 was not supposed to apply to Bangladesh. But Bangladesh thought this transition, this relaxation applies to all countries having an existing patent regime or not. And as I told you earlier, that Bangladesh did have an existing patent regime in 1995, and it cannot stop patenting pharmaceuticals. It will continue patenting pharmaceuticals. But in 2008, the country thought that this provision applied to it, and it stopped offering patent protection to pharmaceuticals, and it started putting the patent applications in the storeroom, and the patent office was required to process the application when the transition period will be over, or when the country will move to the developing country status. And as I told you earlier, that when the patent office will process the application, they are under obligation to give the retrospective effect for the patent application. So now the question is whether Bangladesh did the right thing. So let's give you an example. Let me give you an example. Say AstraZeneca having the patents registered for its Oxford AstraZeneca COVID-19 vaccine under the brand names Covishield, Vaxzevria in the United Kingdom, European Union, US, and other parts of the world, submits a patent application in 2021 for its vaccine at the local patent office called the Department of Patents, Designs, and Trademarks. So AstraZeneca has applied for patent in Bangladesh in 2021. Okay. Upon receiving the patent application, the DPDT puts the application in the mailbox in the storeroom. In the meantime, some local companies, say Incept, Healthcare, Popular, they have the vaccine manufacturing capability, and they have identified the molecules of the vaccines in the laboratories, made the generics of the vaccine by following the required test and error rules and relevant protocols, and started supplying them at home and overseas. Later on, in 2022, 26, when Bangladesh moves to the developing country status, the DPDT processes the vaccine application and grants the patent to the Oxford AstraZeneca COVID-19 vaccine with retrospective effect from 2021. Now, what will happen if the local companies made the generic of the AstraZeneca COVID-19 vaccine? Would it fall within the ambit of patent infringement? As I told you earlier, that the application was made in 2021 and that patent is being granted in 2026, but with the retrospective effect. That means the effect will be given in 2021. And maybe the local companies started producing the generics in 2021. That means the local companies have been in patent infringement since 2021. So what does the Patent Act talk about the infringement? Section 29. Under the prohibition, local companies' acts of making generics of the Oxford AstraZeneca COVID-19 vaccine and supplying them at home and abroad would attract the statutory rewards of making, selling, or using the invention without the patent owner's license, or counterfeiting it, or imitating it during the continuance of a patent acquired by the owner in respect of an invention. It means there may be patent infringements. And regarding the remedies, Section 31 empowers the district court to make such order for injunction, inspection, or account, meaning compensation, and impose such terms and give such directions respecting the same and proceedings thereon as the court may see fit. And I can give you some similar example taken from Brazil. In a similar issue, in July 2019, the Brazilian Federal Court of Appeals for the Second Circuit in the INPI Solis case ruled that mailbox patents shall be granted from the date of filing, meaning a patent infringement suit may lie for producing generics of a mailbox patent. That means there are certain precedents. And for these, Bangladesh might have to face the music. Another question arises whether the above consequence is due to the establishment of the mailbox and whether Bangladesh and LDC having an existing patent regime was required to establish the mailbox. And as I told you earlier, that in no way Bangladesh could issue the executive order in 2008 for stopping the pharmaceutical patent, storing the patent applications in the mailbox, and processing it later on, giving retrospective effect. So Bangladesh was not supposed to do that. Bangladesh was supposed to continue the existing patent regime. Further, can an executive order be treated as a secondary legislation, overriding the primary legislation? Can an executive order override a primary legislation? The Act is saying that the product or process will be patented if it is an invention or it is an improved product or process. So this is the statutory provision. This is the provision of the primary legislation. Can it be overridden by an executive order, which is a secondary legislation? And does the DPDT's 2008 order fits in the rule that can be made under the Patents and Designs Act? the DPT's 2008 order, which is merely an executive order, does not either form part of the Patents and Designs Rules 1933, made under Section 77 of the Patents and Designs Act, or have the authority to amend any substantive patent provisions of the Patents and Designs Act relating to pharmaceutical and agricultural products. To be noted that India, who did not have an existing product patent regime for pharmaceuticals under the Patents Act 1970, tried to amend the Act through an ordinance and interim primary legislation for incorporating pharmaceutical product patents, although the ordinance was not turned into an Act of Parliament. For this, India had to face the WTO's dispute settlement body. On the contrary, Bangladesh, being on a different footing and having an existing patent regime, tries to amend the primary legislation by an executive order, a secondary legislation. Can it do that? Further to be noted that on November 6, 2015, the TRIPS Council, in a decision, exempted LDCs from implementing patents on pharmaceutical products and protection of undisclosed information until January 2033. Then on November 30, 2015, the General Council called on the LDCs to remove the mailbox with exclusive marketing rights for patent applications arising from pharmaceutical products. That means the Bangladesh was not supposed to do that, and if they did that, they are supposed to stop that from November 30, 2015. But the country has not yet removed the mailbox. That means the country is still accepting the pharmaceutical patent applications. It is putting in the storeroom and it will process it after 2026, giving the retrospective effect. And if any pending patent is turned into generics, having the retrospective effect, the country will have to face the music. And what the country can do? The easiest way is to get rid of this conundrum, is to withdraw the DPT's 2008 mailbox rule with a retrospective effect as per the WTO's General Council rollback decision of November 30, 2015, or to issue compulsory licenses for pending patents under Section 22 of the Patents and Designs Act, though there may be diplomatic backlashes and threats. And you might know that for COVID-19 vaccines, there is a demand all across the world, led by India and South Africa, made at the WTO's TRIPS Council to temporary waiver of patent to the COVID-19 vaccine. But the TRIPS Council could not make a decision. They mentioned that such sort of thing cannot be decided in the TRIPS Council. They referred the matter to the WTO's General Council. And maybe it will not be settled since the WTO requires consensus and some of the European countries are not consenting to the temporary waiver. Maybe this issue will come up in the WTO's ministerial conference to be taken place in Switzerland, maybe end of November this year. And in that meeting, developing countries, especially graduating new early developing countries, they have made a decision, they have made a demand to get exemption for pharmaceutical patents until 2034. I'm not sure whether the newly graduated developing countries will have that in place. And I think I should say something about the duration of patent here in Bangladesh. As I told you earlier, that the Patents and Designs Act here in Bangladesh is not TRIPS compliant. And here in Bangladesh, the duration of patent is 16 years under the current act. However, it can be extended for 5 + 5, 10 years. If the patent holder can establish that the patent has not been sufficiently remunerative, but this has not been applied yet. And there are other issues. Say, in the current act, there are exceptions of patent, like research exception of government use. I think it happens in India as well. There are compulsory licensing provisions, but it is not configured in line with the TRIPS. Here, the only criteria to be issued a compulsory licensing, it can be proved that the patented product is not being made to an adequate extent and on reasonable terms. Then there may be a compulsory licensing issued. In addition, if the patent owner gets the patent registered here in Bangladesh, and within 4 years, if it cannot produce the patented product here in Bangladesh, then the government or the High Court Division, as the case may be, can grant compulsory licensing. But it is not, as I told you earlier, that it is not configured in line with the TRIPS Article 31 and 31 BIS, where a product produced under compulsory licensing can be exported to other countries where they don't have the manufacturing capacity. And further, in the TRIPS, you will find a article called 6, yes, on parallel imputation. And actually, the parallel imputation provision is not made mandatory, but the state can do that. And for a country like us, parallel imputation provision is a good thing to do. Say, I can give you an example that, say, some medicine is patented in India and it is being sold in India maybe for 50 rupees, and the same medicine is patented in Bangladesh and it is being sold here maybe 500 taka. And if someone can collect the medicine from India and sell it in Bangladesh for 250 taka, the patent owner cannot prevent him. And here the principle is followed, called the exertion of patent rights. And it is neither mentioned in the Act nor prohibited. The draft Patent Act has provided for the parallel imputation based on the rule of exertion of IP rights. The customs affair rules here also provides that the customs may ask the right holder at the port to produce documents to show whether the product to be imported is manufactured following the due IPR rules in the country of origin. However, it is interesting to be noted that in a High Court Division decision, the parallel imputation has been has been banned. But I'm not sure about the rationale of the judgment. Okay, I think I should conclude here. So thank you.
Thank you so very much, sir. Now I would like to request our participants to kindly interact. Professor Tauhid, dear participants, you may please unmute yourself and state your questions. Please please feel free to interact with Professor Tawheed. Okay, so in case we do not have any comments from the participants, I would like to request our Dean of School of Legal Studies, Dr. Rakesh Kumar Singh, for the final remarks.
Yeah. Thank you, sir. Sir, one question I do have. So far as geographical indications, am I audible, sir?
Yes, I am.
So about regarding geographical indications, whether this Podda Hilish, it is a very famous item from Bangladesh. So whether Podda Hilish, is it, sir, it comes under GI? Or GI has been done with respect to that, because that very Ilish consists of a very. This is my question out of my curiosity, sir.
Okay, it's fine. Actually, before answering that question, I intended to raise an issue on cross-border GI protection. Actually,
right.
There are certain products, say Nokshikata, Zamdani, and some other similar things.
Right.
You do have the same thing registered, and we do have the same thing registered as well. So in the TRIPS agreement, there is no provision on cross-border GI issues. And on this very topic, I wrote an article, and I made a suggestion that in such similar issues, there should be certain mutual understanding for the protection of cross-border GI issues. And for Hilsa Ilish, I'm not sure whether it is registered as a GI. Maybe it is not yet registered as a GI, but maybe it is under the process of registering it as a GI.
Okay. Thank you, sir. So really, sir, your session, the whole session was very informative and at the same time very thought-provoking one. And I'm very much hopeful that it was our participants also have enlightened a lot so far as what is the IP position in Bangladesh and how IP is developing in that very country. And we are very much thankful and grateful to you, sir, for coming and joining our session and delivering a very wonderful lecture with respect to IP so far as development of intellectual property, with a special reference to pharmaceutical aspects in Bangladesh. So on behalf of Patent Promotion and IP Cell, School of Legal Studies and Notia University, we are very much thankful and grateful to you, sir. And we request you to join, sir. We have created a Patent Promotion and IP Cell, and definitely we will invite you and we will request you to come again and again and to enlighten us with your very valuable lectures. Thank you, sir. Thank you very much.
It's my pleasure.
Thank you so very much, Professor Tawheed. On behalf of the organizing committee of this refresher course, the Newton University, and on my own behalf, I thank you for your extremely valuable time and extremely engaging. Thank you, sir. And I extend my warm invitation to you that on your next visit to India, please visit West Bengal and please visit our university campus.
Sure. Okay. Thank you. It's my pleasure.
Thank you, sir.
Thank you, sir. Thank you.
Thank you.
Rakesh sir, should we proceed? Have we been joined?
Tabrez sir will be joining at 7:30. So still we are waiting. And
so what do you suggest? Maybe we can take a break of 10 minutes?
No, let us stay now. We will be joining.
No, we'll stay here. We'll be online. So we can start the session once.
Once we will join.
Sure, sir. Sure. Thank you. In the meantime, one small announcement for all my fellow participants. Kindly refer to the Google Classroom. The assignment section has been updated about 15 minutes ago. Please refer to the classwork section and the assignment, which is due to be submitted on the 17th of September, that is day after tomorrow. A reminder has been posted. Kindly refer to the assignment section and the classwork section for all the further details. Thank you.